are here today at the second episode, not season, only for season. Second episode for the internal show Meet the Furies. Mm-hmm. My name is Andrea, and I will be hosting the part that is focusing on the internal Furies. Maybe some of you know that Zeke, my colleague, he is gonna have several other streams with some of our developer friends. He had one last week. And today I have with me Juliette. She's our first guest.
Hi, everyone.
Juliette is working primarily on the legal things.
Exactly. We call them like that.
First of all, I want to explain a little bit like why we are doing this stream about meeting the Furies and why it took us so long to get it up and running. Maybe it took us so long because we don't have any streaming experience. Only Liam has been doing a lot of streams, and he's tired now, so we are trying to help him a little bit. But why we are doing it is because from the beginning, Raw Fury was about helping the indie developers. We work with a lot of indie developers. We work very close with them, but there are also many others out there that we care about. And if possible, and if we can help in any way, we'd like to share our knowledge. Not that we know so many things, but if something...
We know some things.
Yeah, if it can help a little bit. So that is the main reason. And we've been around for quite some time now. Raw Fury is like 5.5 years, I would say. Soon 6. And I think many people are curious to see who is behind Raw Fury and what do we actually do all the time. Because it seems we just have fun all the time. So that's true.
Mm-hmm. Should we officially get started?
Yes.
Here you go.
Juliette, I actually have a first question.
Please,
legal question. Is it legal to have giveaways in the stream?
Do you want the long answer or the short one? Actually, it's not so obvious to have giveaways. It's okay up to a certain point, but I know that if you, as a company, give giveaways which have a rather high value, you need to report them somehow with a tax authority. I don't exactly remember how it worked, but I know that at my previous job it was a problem if the giveaways were too big in competition and stuff. So the finance department there didn't want us to make too big giveaways, but maybe they were just cheap. I don't know. But the short answer is if it's decent amount. Mm?
Okay, so the big present that we prepared, we shouldn't.
Like the car and stuff like that, no.
Okay.
Sorry, guys.
Yeah, I tried. We're still gonna have some giveaways, right? Let's
yeah, sure, of course.
Some that are legal, then. So how is this gonna work? We are gonna, throughout the stream, we are gonna ask some questions, and the first person who gives the right answer, we are gonna award them. Whoop!
Ooh.
Shall we act professional and
let's do that.
Introduce ourselves?
Yes. Should I get started? Good. So my name is Juliette. I'm a lawyer. I work at Raw Fury. I started here in May. So it's a short time, but many things have happened. It's very interesting to work here. Before that, I used to work during 8 years at another publisher based in Sweden. And it's great to be a lawyer working for this industry. It's very funny to work so close to, the artists, to work so close to the game. The game industry is rather young. It's not so young if you think that there has been games around for a long time now, but if you compare it to the book publishing industry, for example, it's still young. So there are many things evolving all the time, and there's not as many case law and court decisions than in other areas. Actually, there are some, of course, but not as many as you might think. So, as a lawyer, you always need to think and be as well creative with solutions, and so it's nearly like a game. It's very, very interesting.
So even the lawyers have to be creative in the games industry.
And we also have fun.
Yeah. And we need more court decisions.
Yeah. Let's keep on settling like we do.
So, but Juliette, how did you get in the games industry?
So I was an IP lawyer, IP intellectual property, working with content creation. But I used to work on the licensing side. And then, so nearly 9 years ago now, I saw that there was a job opening in a game publisher here in Sweden. And it looked very funny. I remember on the application, I mean, it was written that you should be a lawyer who doesn't like wearing costumes. So I felt it was a bit interesting. And I applied, I got the job, and now I know for sure that I don't want to leave this industry. It's a lot of fun again. So it's really cool to be here. I'm not leaving for a law firm.
I'm not sure about you. Like when I got in the games industry, it was by luck. I didn't even know there is a games industry out there. Were you familiar in any way with the games industry before that?
Not really. I'm originally from France, so of course in France people speak a lot about Ubisoft. It's very famous. But when I moved to Sweden, it was 15 years ago, I didn't know there was such a big game industry in Sweden, actually. There's so many famous companies, but also small ones. It's really bubbling around. Here we are on Södermalm in the south of the city of Stockholm. And it's wonderful because when we have lunch, we just meet people from DICE, Avalanche, Paradox. It's really great. So I didn't know that the game industry was so big here.
Yeah, indeed. It's such a, I would say, strong community.
Yes. It's a lot of fun, actually. Yeah.
Like I come from Romania, and the games industry is totally different there.
Yes.
Like in Sweden, it's much more developed. Now things has been changing as well in other places, but I was very surprised to see the differences when I moved to Sweden. Right.
So what about you, Andrea? Who are you?
Oh.
You're a former lawyer. I've heard you're a former lawyer.
I wouldn't say necessarily lawyer. I have a background in I studied law as well, law and international business, but I was never planning to work in, as a lawyer or, in a court or something. I liked more the commercial part of it.
Yes. So
hence now I'm focusing a lot on the business side. And I started in the games industry 11 years ago at a company in Romania, French one. And
we are everywhere.
And I've always been working on the business and sales side, and I think having a good understanding on some legal aspects helped me a lot in what I do. So yeah, that's what I'm. Like who I am, coming from Romania, moved to Sweden 6 years ago. We actually worked at the same company prior to...
Exactly, yeah. That's how we met.
Yeah, prior to Furies. That's how we started working together. And now we are here again.
Yeah, having fun.
Yeah.
Most of the time.
Yeah. By interacting with several people in the games industry and outside, many of them are surprised when they hear that games companies, they have person working with legal or with business. It's more like, why do you need those? And they're usually seen as the evil people in the room, right?
It's true.
Look at
unfortunately.
us. They're so mean all the time. Right. So, and I think many people are curious to kind of hear, what do we do on a day-to-day basis?
Like a lawyer in the industry. So there are, like in every company, there are so many legal aspects. A major legal aspect in games is, of course, how to protect creation. So when you do a game, you don't want someone else to copy the exact same game. If someone does it, you want to make sure that you can stop them from doing so. And sometimes you want to maybe take inspiration from someone else's game or from a famous movie, from a book. We all have the same references. So how do you do that? How do you take inspiration, for example, without copying? How do you make sure that your game that you spend so many times an hour creating does not get copied? That's a big part of our job. Another one is contract. We will go back to that later on. Of course, contract negotiation. Developer and publisher negotiate and sign contract together. Contract with platform owners, with Steam, of course, Xbox, all of them. With freelancer, we have artists working on our game, artists working remotely. For example, musicians who do music in the game. Usually, they're not employed directly by the game company. So we need to handle all those contracts. Make sure, even internally, make sure that employees sign a proper employment agreement, that we follow rules. So yeah, it's very varied. That's one of the very interesting points. Yeah, but you're right about these things about stereotype. Often people see us like, oh, how can lawyers be in the industry? But there are many of us out there. Many law firms try to get in as well, try to get clients. Publisher or developer, probably because they see how big the industry is. But also, I think because new generation, or I would say people who are under 50, 45, they played games as child already, as a Game Boy or whatever. And so they understand that there are legal aspects, of course. So I hope the view on lawyers will change. But when I get into the industry, it was a challenge, actually, to show that I was not... someone wearing costume and dark and douchebag type of person, So I can't use this one too much. Yeah.
I quickly noticed, we actually have some questions in the chat, and we are going to get back to that as well, but please be patient with us. It's actually our first stream, and it's going to take some time to get a little bit a hold of all the things going on around it. And I also seen that someone says, I should have also a hammer. Actually, I didn't get one, so I just have a spatula.
The usual raw Fury spatula, right?
I will see how we use it. I don't know yet.
Well, I think I will win this fight.
I mean, you usually do, right? You are the lawyer.
What can I say?
So you mentioned a little bit of the things that you are doing. I know yesterday, for example, you just shared with us what was it?
A policy.
A policy, yes.
Yeah. It was about conflict of interest. Yes, indeed, because many people work or have a foot in different game company, and of course you want to make sure that you're aware of who they are, and that's a challenge actually to write a policy in a game company because, of course, it sounds very corporate. And the second challenge with writing a policy is that that no matter in which industry you are, most of the people, they read the policy, they forget about it straight away.
Yeah.
So try to make it funny to read and people to remember. It's quite a job.
Exactly. And
I don't write policies every day at Raw Fury, thank God.
Yeah.
That's not really the kind of company we are.
And the feedback you received was very positive.
Yeah.
People were saying oh, this is the most friendly and easier to read policy, right?
Yeah. But again, as a lawyer in the game industry, you have to be a bit, not to sound too corporate and think a bit outside the box. Yeah. Exactly. Thank you.
Yeah. Shall we get to some legal matters?
Yes? Or do you want to start with a question for giveaways? I don't know. It's up to you.
She is so friendly to you guys today.
Depends on the comments in the chat.
We can definitely do that.
Yeah.
Which question would you like to start with? would you like to ask the first question?
I can ask the first question.
So before you start the question,
Yes.
just to remind everyone how this works, we are going to ask the question. And the first person that gives the right answer in the chat, we are going to reach out and we are going to give you your prize. And because we cannot give today things that are too expensive, we're just going to give away some games.
Yeah, but that's... What else?
Oh, okay. The stream is dropping quality and stopping. Uh-oh.
Sorry.
Is this because you need more time to find the answer for the question? Open the browser.
So...
Yes, we were handling some prizes.
Yeah, and the first question, should we start with it?
Yes.
The first question is, what was the first game Republic launched? Right?
Yes, so again, what was the first game Raw Fury launched? Okay. So until people are thinking about it, hopefully the internet is running well at the same time. Because this is like such an easy question, we would say that. Maybe we can start
With
some legal matters.
some legal matters, absolutely. Yeah.
Ooh.
So should I present a little bit what we're going to talk about? I think we will start with the contracts and the different type of contracts we have to handle in the industry, and also some terms that people should be careful with. And I think this part will be really mostly interesting for game developer, maybe people who have a small studio or are starting their studio and want to get some legal advice or be aware of some issues. And then I think we will focus mostly on intellectual property, like copyright and how to protect creation, if that works for you.
Yes, definitely. So contracts. I love contracts, guys.
Yes, you do.
But there are so many type of contracts and agreements out there, right? Maybe we can quickly list some of them which are more commonly used in our industry, right?
Yes, absolutely, yeah.
And that small teams, and not only, of course, should keep in mind.
I think the contract, which is maybe the most representative of our industry or our work, is the publishing or developer agreement. Depends on which side you are. So the ones that will bound a developer with a publisher. The publisher will take care of the distribution, the marketing, how to sell the game. While of course the developer will focus on creating the game and the artistic aspect.
Yeah. Before we continue, someone actually knew the answer.
Woo!
So we
have a winner.
Woo! Nick Kempton, 1986.
Bingo.
Good job.
Well done.
Congratulations. Right.
But let's go back to contract.
Not too much fun.
Yeah, so the publishing agreement, that's and I think that's usually it's a very long contract. It can be, I don't know, between 20 to 80 pages. And for developers who wants to focus on creating game, I think it can be very difficult to read, to understand, and to know what they agreed to. I would say from experience that often small development studio, not all of them, but some of them, and especially young people starting in the industry, for example, people who started on a project while they were studying together and then they want to pitch a publisher, they often tend to not really read the contract, just sign it because they want the money, they want to get going with their project. And I've seen it mostly at my previous job that I send out the contract, say, okay, do you have any questions? And they say, no, we have no question, and return with signature on. And of course, this is not something I can advise to do. Contracts can be boring and tedious to read, but if you don't understand, just ask. As a publisher, as a developer, you should be able to ask a publisher you want to work with to explain the contract, page by page, point by point. If they refuse to do so, I think it gives you a good idea of how the collaboration will look like after.
Yeah, that's a very good point.
Yeah, and don't sign without reading or understanding, because it will get back to you later on, sooner or later. Yeah.
Do you think that maybe many teams are intimidated by by the fact of like, when they see a contract, and they're also afraid of, what if the publisher or the potential partner is going to change their mind if I ask too many questions or waste their time or takes too long?
It can be so, yeah. Like they want so hard to get a publisher or to be able to focus on the games that they do. So I also think that sometimes people who send out contracts say like, it's just a contract. It's just, it's just our legal team. It doesn't matter. You just sign it. You sign on page 10. It's just legalese. Don't bother. You have to bother. And if you don't understand, it's completely natural and you have to ask. And often in the industry, those contracts are written in English. We all speak English, but of course, legal English can be complicated, is complicated. So again, ask. And if the publisher don't have time and don't answer, you know who you're dealing with, I would say.
Yeah, definitely. Yeah. And what do you think are the main terms that should be covered in a publishing agreement?
So of course we have all the financial terms. I guess we'll get back to them later on. But usually people are very careful. They want to know how much they will get paid. So people look at the financial. I think one which is super important is intellectual property right and ownership. Will you give away as a developer the ownership of your game to a publisher, meaning that the publisher will then own the game, be able to do sequel, everything without you, change the IP, develop the IP, or just drop it dead and don't work on it anymore?
And also, I guess it's important to have very clear in there if you can get the IP rights back and how that would happen.
Exactly.
When... Right?
Yeah, exactly. So if the contract gets terminated or once the game is shipped, will you be able as a developer to work on the sequel, on DLCs, on the future development? That's a big question. My advice would be, if you are a developer and you really want to keep the IP ownership, apart from working with Furies, because we usually let the developer keep the ownership. I think if you're working with a developer who do not want to give up on the ownership, is to ask for what is called the right of first refusal. If the publisher wants to do a sequel, they will have to ask you first.
Yes, so we are talking about the publishing contract and important aspects of the publishing contract. You mentioned a little bit about the IP, right? Exactly.
So important. So again, just before we were interrupted, I would recommend developer to keep, if they can't keep the ownership, to negotiate a right of first refusal, so that any sequel, DLC, any future development will be proposed to them first.
Exactly. Yeah. And what about merchandise or other rights for that?
Yeah, it's then it's a question of negotiation, I would say. Usually the publisher will handle also merchandise, but I think in general, as a publisher, you should have an open dialogue and make sure you clear those things in the contract or during the negotiating parts. Because maybe you will have a lot of good ideas about merchandise. Let's do plushes. Let's do, some crazy T-shirts. And it's good if you're both in the same boat, if you both agree with the publisher. So, this is really, you need to work on this in the contract and outside to make sure this collaboration works. Yeah. And often the contract, I would say, is a reflection of the relation.
Yeah, exactly. Keyword collaboration.
Yeah.
And so we talked a little bit about IP rights.
Yes.
And we mentioned also financial terms, which maybe we can cover a little bit now.
Absolutely.
I think, from my perspective, it's very important to know like, of course, how much you'll get paid and when, and if there are any milestones or not. That depends from partnership to partnership. But something that I think it's very, very important, and I've seen it in all kind of publishing agreements, it's the way the publisher is recouping their investment in the developing. And there are different ways of doing that. And sometimes they do it against the net revenue. Sometimes they do it against your part of the revenue. And you will see that. And that's a totally different way of doing it. The main difference is if they do it against your part of the revenue, then they will have to recoup double the amount until you get some money. So I think that is an aspect very, very important to look at, because it's just a word there, and it's so easy to miss on it.
Indeed, yeah.
Yeah.
Should we put on the next slide? No?
Yeah, we also have a PowerPoint here.
Ooh.
But,
something else which I think should be mentioned is, of course, the delivery and redelivery of the game. Many publishing contracts ask, of course, the developer to deliver the game at different stage of development. And if they're not satisfied, you will have as a developer to redeliver. So please read those terms carefully. How many days will you have to redeliver? What happens if they still do not like the game? How can the agreement be terminated in those cases? So these are also very, very important terms that you should be careful with. And again, if you don't understand them, please ask. And if the publisher terminates the contract not because the game is bad, but just because they want to focus on some other kind of games, I think you should get your IP ownership back, so you can still work on that game later on and find maybe another publisher, just so that all the work done is not thrown to waste.
Yeah, exactly.
Yeah.
Maybe other things you could also have in a publishing agreement is who is doing things like quality assurance, who is doing localization, age rating, porting, licensing for the software you might be using. It's always good to have these things clear from the beginning, and in order to be able to estimate exactly the cost of the project. Of course, the marketing side.
Marketing side, yeah.
As well.
Is there any minimum marketing budget, for example, in a game?
Yeah. Exactly.
Yes, of course.
What are the general obligations, right?
Exactly.
Okay, so what other contracts we should briefly mention?
I think one very important, maybe mostly for publisher, is a contract, of course, for distribution. So it can be with first-party platform owners, like with the App Store, with Steam, for example, or with also different kind of distributor, let's say Good Old Game or Humble Bundle. Usually those terms are rather standard, I would say. But of course, you need to make sure what you agreed to. If you have a publisher, usually it's the publishers that go through them. It's sometimes hard to negotiate, but sometimes it goes. Yeah. You should know about that, Andrea, working with sales and.
Yes. So most of the platforms, they have their standard agreements, and what I've seen, most developers and publishers, right, whenever they are submitting to create an account, right, they by default agree on the terms from the platform, right? Even without reading them. And I know in most cases they are not flexible at all. They are not going to make a change. But it's very important that at least you are aware of what you are committing to. There are some clauses in there that say things like you have to sim launch with other competitive platforms. You have to update at the same time. You are not allowed maybe to share numbers, financial numbers with any third party. So there are some things in there that I think will be good to keep in mind long term, so that you don't upset anyone. But then there are some other distribution contracts that are discussed on a case-by-case basis, like special deals.
Yeah.
And I've seen in many cases that because you are usually talking with a bigger party, I would say, like they came across as like not willing to negotiate. Especially in some countries, the terminology is even harder to grasp, I would say. And my only feedback is to try to ask questions and not let yourself intimidated by all the things that are in there, and never sign something without really understanding what you are committing yourself to. Yeah. About distribution contracts, something that I noticed in some of these agreements are the termination clauses. Many of them have as a termination clause the fact that it renews by default, right?
Yes. Yeah, indeed.
Yeah, and unless if you reach out 6 or 3 months beforehand, which I think is something that many of us miss on.
Yes.
It's like so complicated to just put a lot of reminders like, oh yeah, indeed. I have to reach out 6 months before if I want to terminate the contract. And yeah, like something like automatic renewal. It's a clause that I usually try to change.
And avoid. No, I perfectly agree with you. Yeah, exactly. Termination clause in general are good to check. Of course, you want to know how the other party can terminate a contract. Sometimes termination are often based on breach when someone does not fulfill its part of the agreement, but sometimes it's also on convenience. So the contract can be terminated for no reason. After 1, 2, 3 months, it's good to keep that in mind so that you know what you agreed to.
Yeah, exactly. Yeah. I just wanted to check if the chat is still running well.
Are you all sleeping?
Exactly.
Or amazed?
Okay, it's working.
Let's get going.
Okay, thank you. Yeah, indeed. The distribution agreements are some agreements that we work with a lot, and other things that we pay. We are very careful of to pay a lot of attention are like any exclusivity aspects that are requested in there. Then, if that kind of distribution comes with any marketing package and what that involves, and. In many of these agreements, it's going to say like, yes, the partner, the platform is going to provide marketing support, but it doesn't say what. And that is like so misleading, and it's like it doesn't say much. And I think it's better to have a good understanding from the beginning that not much is going to be done. If they're just going to do a social post that like something on Twitter, that is fine. But I think it's good for you to know beforehand what to expect and not just rely on the platform.
Should we speak about another contract, which are known as work for hire and freelancer? Often parts of the game, for example, the music or some assets are done externally by a freelancer. And it's really careful to have a contract in place so that the ownership of their content that you will include in your game is transferred to you. And also to make sure what those rights are. A typical example, I think, from the game industry is buying some music that you will put in your game, but the rights are limited to putting the music in the game. It cannot be streamed. You cannot allow people to do mods. You cannot put this music in a sequel.
Can we sell it?
Exactly.
On different stores?
Or put it on Spotify, whatever. And sometimes also there's a limit in time. So you can only use that music for 2 years, 3 years. Well, if your game is a success, hopefully it will still be available in 5 years, 10 years. So really those contracts are important, and you need to read them carefully and make sure all rights are transferred.
Right. And there are many cases, I assume, when a team just reaches out to a friend, is like, can you help me with some art, with some music? Maybe there is a contract, maybe not, but it's very brief and doesn't really explain what it is for and for how long if it involves like revenue share, for example, for how long that is going to be. Maybe you want to pay the freelancer during the development or maybe during the first year or two, but I don't know, do you want to pay revenue share from each and every sequel or merchandising even if they don't work on it longer?
That's a risk indeed. So it's important to be very careful with that.
Right. And I guess it's quite common not for many developers out there not to sign this kind of contracts, right?
Yes, it is true. And often then as a publisher you ask, but can we use the music in another game or in the sequel? And they're like, I'm not sure, it's a friend who did it, but he was cool with that. And it's not enough. If the game is very successful, I don't know, the musician, she will ask for a royalty or, of course, so you need to make sure to clear those rights. Also because, of course, every artist has an attachment to what they create. So you really have to make sure that both parties understand what they agreed to.
Yes. But I think like one of the biggest problems is that drafting a contract can be very expensive especially if you have to reach out to legal firms. So when you don't have a big budget for your game.
So one possibility, actually, there are some contracts online. They're not always good, but it can give you an idea. If you go online, for example, and you want to find a non-disclosure agreement, maybe you will find a draft or something that can be a start. More generally, I would say that a contract is still a document where people agree. It doesn't have to be written in a complicated way. So your contract can be a contract between A and B. We agree, 1, that this music can be used in a game, in a sequel, in everything. 2, even for stream. C, I will pay you $500. D, it's perpetual. It can be just sentences like that. It doesn't have to be again written in a complicated way. What you just want to make sure is that it reflects the intention of the party. And if you end up in court, that's what the judge will look. We'll look at what was the intention of the party when they agreed to it. Yeah. So again, it's better to have a one-page, very clear, very easy to read than nothing. Because otherwise it will be like, but you remember 5 years ago we said I could use your music. No, that's not what I said. And then it's, how do you prove those things? You know, it's really complicated. Yeah.
But isn't written email communication enough?
It can be seen as a contract. It can have the value of a contract, of course. If you say, hey, I want to buy your music, I give you $500. If you deliver it before 1st of January, the person delivers the music, and then you say, you get 200. That person can say, come on, we said 500. So no, it can be used as a proof or as a contract, indeed. Then, of course, but that's me being a lawyer. I like when it's a bit more formal, because if you just write contracts, make people realize that it's important, that you have to follow obligation and make sure you stick to it. Yeah. But again, it doesn't have to be so complicated.
Yeah. The most important, I guess, is to think about all the ways you are going to use it and clarify that from the beginning. Right. Yeah.
I also think that many law firms want to get into this industry, which is really booming right now. So I think you could also contact a small law firm and say, look, I don't have a lot of money, but can we reach an agreement? Can we just pay us a fee per year for, let's say, 10 hours of of advice? Or, I think you can reach, you can find solutions, if you want to.
Right. Yeah, that's a very good point because
yeah.
we know that many law firms, they charge per hour, right?
Yes.
And there is this impression that they're just gonna try to find more and more things in the contract so that they can charge you more. We wouldn't say that this is, true for everyone, but yeah,
But it is in many cases, yeah.
right, yeah. So the good advice, you like a fixed fee.
Fixed fee is good, yeah. And the young lawyers who also like games and wants to, to work with games. So I think there are possibilities there.
Pay them in games.
Yeah.
Talking about games, shall we give another game?
Yeah. Question time.
Yeah. Let's see if is anyone around. Guys and girls, we didn't mention that actually this week, if I'm not mistaken, I hope not, we have another release, a new game coming out.
Yeah.
And
on Thursday.
Yes, exactly. So very, very nice game, and maybe we can give another key for that game. Ta-da! I just changed the background because someone asked in the chat about that. So the game is called the Signifier.
Mm-hmm.
Very, very excited about it. Yes, good. Yeah, but that wasn't the question. Guessing was the game.
Woohoo!
But let's ask maybe 2 questions and give the chance to 2 people.
Yeah, let's do that.
To win this amazing game. So next question is a very, very difficult one.
Yeah.
But if you've been following us for some time, maybe you will know. If not, you'll have the time to go and make some research. Okay, are you ready? What is the favorite root vegetable for all the Furies? Yes.
A legally challenging question.
Yes, we all like the same.
Oh la la, many
vegetables.
people are following. Look,
Swedes, yes.
Swedes are not Swedes are not root vegetables.
Okay, someone answered.
Someone who answered. Woo!
Yes, that wasn't so difficult, right? Yes, that's true. We love potatoes, all of us. We have to love
One
potatoes.
of us especially, I would say. I won't give any name, but...
Cool, so... the next question, and you can choose. You can for this one, you can choose if you want a key for the signifier or if you want a key for the game that we are gonna ask about.
So the question is, what is the name of the game where you play as a cab driver and you interact with all kinds of passengers in order to catch the serial killer? And I think we spoke about this game in the stream last week.
Yes.
Woo.
The stream where Anthony wasn't present.
Yeah, I think we have an answer.
Good job, guys and girls.
A very nice game.
Yes.
Let's go back to legalese, no?
Exactly. Yes, and we are also taking questions about any kind of legal aspects. We had a question earlier on, and we are gonna get back to it in a bit. Trademark. We are gonna cover trademark a little bit. But by the way, do you know that we have only 10 minutes left?
10 minutes left, so let's get going. No time to lose.
I want to ask really quick, Juliette, about non-disclosure agreements and
Yes.
mutual non-disclosure agreements. What's the difference between the two of them?
So a non-disclosure should I wait for the... So here we go. A non-NDA, non-disclosure agreement, is of course about keeping confidentiality. And I think it's important when, for example, you show your game for the first time to a friend, maybe not to a friend, but to a business partner, a distributor, to all your friends, sorry, I'm a bit too, to a business partner that, for example, you have to sign an NDA. It's normal. You don't want people to speak about, your project and confidential aspect of it.
Yeah.
And when there's a M before, mutual non-disclosure agreement, it means that this agreement is both-sided, both parties agreed to keep confidentiality. So my recommendation, if someone proposes an NDA, is to check if it's mutual or not, because at least if it's mutual, you know that the terms will be fair, because of course no one will ask you to sign an NDA, a mutual NDA, which is not fair for them. Yeah. Confidentiality in general is very important, and especially when you want to announce the game, maybe you want to make a big thing about it. So it's not really funny if everybody speaks about this game before. So a typical example is to ask, for example, beta tester to sign NDAs. This is completely standard.
Right. So that they don't show your game to the world, and in many cases it happens they don't do it intentionally, right?
No, I think many people do that in good faith. They speak about what they work on, what they see, if they are a beta tester, what the games they are being playing. But of course, it can ruin your marketing campaign if you wanted to make an announcement, or if you're not sure about some aspect of your game, you might want to change. Of course, you don't want early version of your game to be online, or pictures of it to be spread out before you're sure to have the final version. So it is indeed important. Not so many people think about it. Maybe as a developer, they feel a bit insecure to say, please sign a contract. But in this case, I think it's important in many cases, yes.
Yeah. I think quite often we hear from developers the question if we as a publisher will sign an NDA before they send a pitch to us. And I think like every developer would like to have the NDA signed, but it's not as common, right? When you're talking to a publisher.
Yeah. It's not
when you're pitching the game.
Sometimes maybe it's not so common because publisher do not want to sign anything that could make the developer come back to you later on and say, oh, look, this was part of my pitch. So this other game that you're doing is just a copy, you owe me royalty. Sometimes as a publisher, you can get pitch games which are very similar. I don't know, let's say a pirate game. Of course, they will have similarities, so people may be reluctant as publisher to sign confidentiality. But in this case, as a developer, you can just say, please, let's keep confidential the fact that I am working on this type of game, or that I plan a release in 6 months, whatever the stage of development. You can ask, I think it will be no problem.
Yes, exactly. I mean, a publisher usually receives like hundreds of pitches every year.
Yes.
And before they see your game, they don't know if it's something very similar, as you said, to something they already have in their portfolio, and maybe they haven't announced yet. So it's just more a mutual trust.
Indeed,
with publishers. Shall we cover a little bit about trademarks and copyright?
Trademarks and copyright. Let's move on. So it's a big part of a work of a lawyer in the industry is to protect assets and name and, for example, the title of your game. Title of the game, it will be trademark, but first I would like to focus on copyright. Copyright is the protection of every aesthetic or creative aspect of a game. The music, a particular set, some catchphrase. It's a bit like when you publish a book, it's automatic protection. In the US, you can also register copyright to get an additional protection, but even without it, you get that protection. When you release a game, it's protected by copyright, like just when you release a book or a movie. And something important to know is that you don't get a protection for the ID, but for the interpretation or expression of it. So, for example, if we go back to this example of pirate game, if you do a pirate game with a little parrots and all those stereotypes about pirates, it's not protectable per se, but it's the way you express them. If you do something something original, the way you will design your pirates, in those cases there could be some protection. There's a very famous case about that. If you have time to look for it, is one of the oldest lawsuits in the game industry, which is Pac-Man versus Casey Munchkin. And there is a comparison of those two games, and Casey Munchkin was found to be an infringer, was to copy Pac-Man because. Of course, to do a game with a little ghost pursuing, a character, which a round character is not per se protectable, but they were copying so much the assets, the atmosphere, the look and feel, that it was considered to be a copy. So, guys, if you have time, and girls, look at that on the internet. Pac-Man versus Casey Munchkin. Yeah, so one thing to keep... Oh, sorry.
No. So, do you want to touch also about trademarks, or
I will just before we finish on copyright. I would like to speak about fair use. Fair use is an exception to copyright. For example, as a journalist or someone doing a critique, you can mention a work. I think there's a misconception that in the game industry, many people think that parody, which is part of fair use, can be used very liberally. For example, you could put, a character from Star Wars in your game because it's a parody. You make fun of this character. But it's not as easy as it sounds. Really, to really be a parody, if you're selling your game, it can have a commercial aspect. So be very careful. Ask for a license. Be careful before using anything on the internet or anything that looks like a parody. That's it on copyright.
Trademarks.
So it's
that's something more common, I think, right? For on a day-to-day basis.
Maybe because copyright is automatic protection, but trademark is not. A trademark, you have often to register it to get protection. It's a recognizable sign or design expression which identify a product. A very famous trademark, for example, which I think is a good one, is Apple. Not for selling fruits, but for selling mobile games and hardware. So it is expensive to file trademarks.
How expensive? Can you?
So in Europe, for example, the fee to register a trademark at sea, it's between 1,000 and 1,500 euro just to send the application, to which you will have to ask maybe an attorney to help you. And there may be some opposition from another company judging that they own a similar trademark. So it can go up to 5,000 in worst case, yeah.
And this price, 1,500, you said, is like per group. So, right? It's like, okay, you can apply for a video game, but if you want to apply also for merchandise or board game, you just add more classes.
Have to add more classes of goods.
And it's more expensive,
And it's more expensive. So my advice will be that, of course, it's difficult for a small studio to pay such a high price. Maybe you want to put your money on something else, like working with a freelancer, I don't know. But I think the most important with IP is not so much to protect what you're doing, even if it is, it's also to make sure you do not infringe on somebody else's rights. You do not want to choose a name for your game which is too similar to a game which is already released. So a good advice is to check, and you don't need a lawyer for that, to check on the internet, to check on the platform you want to publish your game on. Let's say Steam, if there is already a game with a similar title there, out there, and then change it, of course.
Yeah. And I remember you told me before, and I see you have it also here on the slide, that it's of course recommended to be original and not use like a common word, but add like a descriptive word to your name.
Yeah, the more original you are, the most likely it is that you will be the only one having a trademark with those terms, and the more likely you will get a registration. It's not allowed to have a trademark for something which is too descriptive.
Right.
For example, we could not be able to trademark computer game. Because if we would get a computer game trademark assigned to us, no one else will be able to use these terms. Of course, it's not possible. But I think that in the game industry, many games have a name which starts with the names, I don't know, Knights, Citadel.
Kingdom.
No, but names which are very often used in our industry, and maybe it's a good marketing strategy. I don't know, but if you're more looking for trademark protection, I suggest to be more original.
Yeah. So someone is asking in the chat. So if you do your homework, you don't have to trademark.
I mean, the advantage of having a registration is that you can easily remove infringer. So if someone else tries to sell a game with the exact trademark, you will not have to prove so much. You will have your registration, which is in itself a proof. So it helps a lot. But again, if you're just starting doing business, you don't want to put too many money maybe into it.
Exactly.
So focus first on not infringing yourself.
Yeah, as you said, a few €1,000 or dollars. It's a lot of money.
Yes.
I think it also depends on like how popular your game is.
Yeah.
So for example, when a game takes off, there are sometimes people who maybe intentionally or not, they might submit the game on a platform backend. So they might use that title, and then when you are trying to make your submission, you realize that the name is taken, and you have to send them a trademark registration. And that's the only way to get your name or to be able to use that name that maybe you've been using in marketing materials for a couple of years now, but only now you got to the point when you are close to releasing your game, and you start looking into some submission. So I think it's good, but maybe it's not something you have to start right away.
Exactly.
Maybe just like try to book the name in the back end if possible. And you don't have to do it right in all the regions, right? Maybe you can start with one region. You don't have to, like US, it's quite different.
Usually we do it in the US and in Europe here in Raw Fury, and there are different systems. Like usually in the US, it's a first to use principle. So the first person to use a trademark have the ownership. Then you may have to prove it, but in Europe, it's different. It's a first-to-file system with trademarks. So the first one to ask for trademark registration is the legitimate owner. Then you can also discuss and prove that you have you've been using this trademark for a longer time. But it's a complicated process.
Exactly.
So yeah, indeed, if the game takes off, you should probably register your trademark.
Yeah, and in other countries, like in Asia, right, it's a different process.
It's a different process as well. Right. Yeah, indeed.
But, I wouldn't worry, like, personally as much about those regions, because usually they would be using localized name for the game. It's different, and it's anyway so difficult to track what's happening there if you are an European or a company based in the US, for example. So maybe start regional if you think it's needed, and you'll grow after that.
Yeah,
exactly.
Do you still have time?
No, I think we're
good.
Yeah,
we should do a number 2 soon.
Exactly. Yeah, it's been like there are so many things that we could talk about. Yes. So many things we didn't even touch on. But we are very open to hear from you guys and reach out and try to answer more questions via email, on social media. So we are here. Yeah, thank you for being with us.
Thank you
today, and for being so nice to us during our first stream.
Yeah.
Everyone in the chat have been very friendly, almost everyone. And thank you, Liam, for all the help, and thank you also to Rachel and Zeke for helping us with all the assets and for promoting the stream, and for all the Furies for willing to be part of this stream and sharing the knowledge with everyone out there.
Are we officially done?
We are done.
That's it.